We turn our attention now to the latest in the murder trial of Kyle Rittenhouse in Kenosha, Wisconsin. New tonight, Governor Tony Evers has announced about 500 National Guard troops have been activated in anticipation of a possible verdict next week. Both the prosecution and the defense rested their cases on Thursday. The jury is set to hear closing arguments on Monday and begin deliberations after the judge gives them their instructions. Back with me is veteran prosecutor and legal contributor Paul Henderson and criminal defense attorney Latoya Francis-Williams. All right, Latoya, troops have been activated. Is this a safety precaution, or does this indicate what the verdict will likely be in this trial?
I think it's definitely a safety precaution. We cannot predict what the verdict will be in this trial. The difficulty in trying to predict the verdict in a trial is the jury is bound by the instructions given, which we don't have as yet. So right now, I think we're safe to say this is a safety mechanism, and it's well needed.
I know, I understand why you're saying that, but I can pretty much predict what this verdict is going to be, and I think everybody else watching this trial can too. Paul, your thoughts?
Okay, well, I find it awfully ironic that we're talking about state action to address protests when the whole core of this case is about a response to protests from, I mean, obviously, the case about expanding or challenging the parameters of vigilantism on behalf of law enforcement response, because at the core of this was the George Floyd. And the reason that I think it's important, the reason I'm raising that issue is because as we're talking about it, I don't want us to drift too far away from the conversation about race that frames all of this. That is why all of this matters and why so many people have leaned into this conversation right now. And so to me, like I said, it just feels ironic that we're now talking about the results and the ruling from this case, what that opens the door to in anticipation of potential protests, that we're going to have more law enforcement. It's not lost on me that we're talking about it in the context of an enforcement agency that has not gone through many of the necessary reforms that are at the core of the initiation of this case in the first place. So those are my thoughts.
Well, Paul, the defense, let's talk about the defense and the prosecution in their case. The defense has created doubt through their own evidence, including the testimony by their star witness, Kyle Rittenhouse, but the prosecution fumbled because their own witnesses also helped raise reasonable doubt. What does the prosecution need to focus on in their closing arguments on Monday that could possibly turn the tables?
I mean, I think there's only one place for them to go, and that is for them to go back through that testimony, those docs, argue to the jury that they have to remind the jury that this was an individual that came prepared, armed to a protest, and then, because he felt scared, responded to them. I mean, if it were me, that's exactly what I would be arguing and trying to remind them to look at the smaller micro picture and image that they are forced to by the instructions that they will be given, that to the degree they believe that self-defense is a possibility, it has to be in every single one of those instances where he used lethal force, that the fear was reasonable and that the use of force was justifiable. And that two prongs has to be met with every single person that was attacked or shot by the. So, I think it's going to be really difficult argument given history of this case, given how the trial unfolded, and prosecution is behind the 8 ball, but so many in the case argument, even with their own witnesses that they on the stand. So there's a lot of ground that they're going to make up for a credible argument or try to overcome the burden. And then they've still got the mistrial loop.
Right. No, Latoya, to you, the defense, they could have rested their case without presenting a shred of evidence and still have reasonable doubt, but they did present their own evidence in the form of witnesses. What will they be focused on in their closing arguments?
They absolutely have to be focusing on the accused. A lot of times as defense counsel, we choose not to put the accused on the stand because sometimes cases become more about whether you believe, like, or persuaded by the presence of the defendant in this case. At this point, because the state, I do agree, has made some fumbles with regard to their own witnesses, the defense has to literally poke holes in each element of each offense that is charged. As we've seen today, the issue of whether provocation is going to really be the gravement of the argument for the state is something that the defense has to focus on. In this instance, there's no question that the state's, at least one state's witness has admitted that Rittenhouse shot after a gun was pointed at him. Plain and simple. The difficulty is what happened before that? What provoked that alleged pointing? What provoked the skateboard to be swung at Rittenhouse? And so in terms of what the defense needs to be doing, is the reality is you win these cases from the defense standpoint on the law. A lot of times persuasion is important, but you win it on the law. Every element of each offense, if it is not met, then the verdict has to be not guilty on the charges as they are brought forward. In terms of lesser and included offenses, again, the defense has the uphill battle, but they've got to address each and every element of each and every lesser and included offense that will be provided to the jury as they deliberate through the instructions that will be read on Monday.
Let's talk about the judge presiding over this case. I'm not a fan. I mean, of course, it's easy for me to see how he's more defense friendly because we know what his rulings are. We get to hear him rip into the prosecution, all the things the jury doesn't get to know or see. But how could they not feel the tension between the judge and the prosecution? Paul, what kind of impact do you think that can have on the jury?
It has an absolute impact on the jury, and even though they may not be in the room, especially during those times when the judge was excoriating the prosecution, and it's very clear, at least from the rulings, that the judge does not appreciate either the prosecution's case or the prosecution's lawyer, but I believe he probably doesn't like either one of them based on his commentary and how he's communicating to counsel. But that absolutely has an effect on the advocates that are in the room, especially for prosecution, because when the case comes back on, when they're brought back in and the questions begin, you can see that there is a marked shift in the conversation. There is a different tone and presentation from those lawyers that have just been dressed down in front of the courtroom like that. And not for nothing, I think it's really relevant to note that the judge has indicated already to both sides that he has ruled against the prosecution. He shut down the direction and the line of questioning, both in limine motions and as reminders throughout the trial in different directions, and also indicated, and this is very telling, that the judge has already told them that they have crossed the line in some of his rulings. That opens the door and declares to the defense attorneys that if they don't like the results of this case, that they can make a motion for mistrial, and in front of this judge, it's likely to be granted based on his comments that he's already presented to both advocates. That's a hard hill to climb.
Excellent point. Paul Henderson, Latoya Francis-Williams, thank you both for joining me tonight. Thank you.